Ms. Hughes, please come forward to be sworn.
Can you spell your first and last name for me?
Sky, S-K-Y. Hughes, H-U-G-H-E-S.
Raise your right hand. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Go on.
Thank you, Judge. Good morning, Ms. Hughes. Can you tell us your full name, please?
Sky Lee Hughes.
And Ms. Hughes, are you married to Chris Hughes?
Yes, I am.
How long have you been married?
10 years.
10 years. Do you know Travis? Did you know Travis Alexander?
Yes, I did.
How did you know Travis?
We were good friends.
How did you meet him?
I met him at church.
And were you already married to Mr. Hughes at that point?
Sorry. No, I was not.
Okay. So you met him when you were still single?
Yes.
And about when was that?
In about 2001.
All right. And so had you known him continuously since then?
Yes.
Eventually, when you and Mr. Hughes got married, I take it you both were friends with him. Is that right?
Yes.
And did he come over to your house a lot?
Yes.
Did he spend a lot of time with you and Mr. Hughes?
Yes.
And eventually, you and Mr. Hughes have a son?
Yes.
And did he spend time with your son?
Yes.
Did he ever sleep over?
Yes.
Would he spend the weekends at your house?
Yes.
And would he go to church with you all together?
Yes.
All this time that you spent with him, I imagine you got very close to him?
Yes.
And you cared about him?
Very much.
And you loved him very much as well?
Yes.
In the last 4 years, since 2008, you've been interested in what's been going on in this case, right?
Yes.
And because of the care and so much how much you cared for Travis, I would imagine you care about what happens in this case, right?
Absolutely.
Because ultimately you would be hoping that Ms. Arias is convicted.
Yes.
And in the last 4 years, your interest has included contact with the prosecutor's office, right?
Yes.
And you've spoken with the victim witness advocate?
No.
Who have you spoken with?
I've spoken to Philip and Mr. Martinez.
Okay. Was there somebody else that you were going to say?
No.
Okay. So Philip, and just to be clear, that's Mr. Martinez's paralegal, right?
I believe so.
All right. And you've spoken to Mr. Martinez himself?
Yes.
And this is over the last 4 years?
Yes.
And you have been watching the trial since it started, right?
Yes.
And you've been watching it, I guess, because it's being live streamed?
Yes.
And when you're watching the trial, your contact with the county attorney's office is continuing, right?
Yes.
And when you're watching the trial, you're watching to see if there is any inconsistencies or things that might be helpful to the prosecution.
I watch to see if there's things that I remember or that are, inconsistent. Yes.
Okay, so in other words, if there's something that's helpful to the prosecution, you would have contact with the prosecution to let them know that.
If there's something that's helpful for Travis and his case, then I will let, the prosecution know.
Okay,
Yes.
and if it's helpful for Travis in his case, it would be helpful for the prosecution, right?
Yes.
Okay. And so your contact with Philip and Mr. Martinez has continued throughout this trial, right?
Yes, much less than in the beginning, but yes.
All right. And on January 15th, you received a call from the county attorney's office?
I don't know what date it was, but
The call about Gus Searcy.
yeah, I don't know the date, but I did get a call about Gus.
Okay. And who did you speak to about that?
Philip.
All right. And what did Philip tell you?
He asked me if I knew Gus Searcy. I said yes. And he says, how do you know him? And I said, he works with Chris in Legal Shield.
Okay. And do you remember, I know you don't know the date, but do you remember the time approximately of when you got the call?
I don't. Sorry.
Okay. That's okay. Do you have any memory of whether it was morning or late night?
It wasn't late night.
Okay.
It was probably morning.
More morning
sometime.
time?
Yeah.
Okay. And did you communicate your conversation then to your husband?
Yes. I had to ask him for a phone number, so yes.
I'm sorry, you asked?
I asked Chris for Gus's phone number
Oh, why did you do that?
to give to Philip.
And because Philip wanted to have Mr. Searcy's number?
I just said I might have his number. Let me get it.
Oh, okay. And so did you ultimately give it to Philip?
Yes.
And when you were talking to your husband about it, what is it that you told him?
I said, I need Gus's number. He says, why? I said, Philip needs it.
Okay. And did Philip tell you why he was asking about Mr. Searcy?
He said that the defense was going to be calling him.
Okay. And so, any other part of your conversation with your husband then about this?
No.
So, you told Mr. Hughes, or your husband, that the prosecution was wondering why Mr. Searcy was being called?
No, he wasn't wondering why. He just asked for his number.
Because he was being called as a witness? Okay. But that part you communicated to Mr. Hughes, your husband?
Yeah.
Okay.
Oh, sorry, yes.
Okay. And were you present when your husband texted Gus Searcy?
No.
And were you present at all during the conversation that your husband had with Mr. Searcy?
No.
And did you talk to the county attorney's office again that day?
I don't think I did.
Okay. Did you call Philip back or Mr. Martinez back to discuss what the conversation that your husband had with Mr. Searcy was?
I don't think so, no.
Okay, so did you never advise Philip that Mr. Searcy had a phone call, that Mr. Hughes had a phone
Oh, no,
call?
I said Chris talked to Gus.
Oh, okay. Do you have a memory as to when that was?
Maybe the next day or the day after that.
Okay.
I was talking about something else
To whom?
to Philip.
Oh, okay. You were talking about something else to Philip and then you also told him about the conversation with Mr. Searcy?
Yeah, I said Chris talked to Gus.
Okay. And did you summarize the conversation for Philip about what your husband talked to Mr. Searcy about?
No. I mean, I just said that he talked to him. He said, why? And I said he just talked to him about that they were going to be meeting together later. Chris was doing an event, a seminar, and Gus was going to be there.
Okay.
And that I asked him if it'd be okay if Gus and Chris saw each other, like if that was going to be a problem.
Okay. And what did Philip tell you?
He said, no, it shouldn't be a problem.
Okay. And did Chris share with you the fact that he told Mr. Searcy that he thought the defense was lying or like a snake?
I don't remember if he told me that or not. He just told me that Gus said that he had information that could hurt Jodi or help Jodi.
Okay. And anything else did he tell you about their conversation?
Not that I remember. That's basically what I remember from their conversation.
Okay. And then after you knew that your husband had spoken with Mr. Searcy, then it was a day or so later that you spoke to Philip and advised him of that?
Yeah. That's not why I called him. I called him about something else, and I just asked when I was on the phone if it would be okay because they were going to be at a seminar together.
Okay. Why did you call him?
Because I had remembered something, then I just thought he should know.
What did you remember?
Jodi had told a friend of ours that she got baptized for Travis.
And so you were
Just
helping
letting Philip know that.
Okay. And did the prosecution ever advise you or your husband, at least to your knowledge about your husband, that you were listed as defense witnesses?
No.
They never told you that?
No. Well, I asked him if he was going to be using me to testify. He said he didn't think he would be, and I said, "What about defense?" He says, "I don't know if the defense is using you or not."
And when you say he, are you talking about Mr. Martinez specifically?
Yes. We hadn't received a subpoena or anything.
Okay. But he didn't tell you specifically that you were listed or not listed. He just said he didn't know?
No, he didn't say he didn't know. He just said he didn't know. I didn't ask him if we were listed. I asked him if we were going to testify or not, and he said, I don't know if you're going to testify or not for them.
Okay. Right, so he said that he didn't know if we had called you, we're going to be calling you to testify.
Correct.
Okay, all right. And so I take it also you were never advised then not to watch anything on the media?
No.
All right. And you have been continually watching this case since it started in trial, right?
Yes.
All right. That's all, Your Honor.
Ma'am, the prosecutor never advised you to tell your husband to talk to Mr. Searcy, correct?
Correct.
And the prosecution never told you to contact any witness to attempt to influence them in any way, correct?
Correct.
And if there were any calls that were made at that juncture, they were mostly between you and Philip, correct?
Yes.
And with regard to the issue involving Gus Searcy, he called you and asked you about Gus Searcy, and you provided a telephone number, right?
Right.
At no time did Philip ever indicate that Mr. Hughes was to talk to Mr. Searcy, correct?
Correct.
And then later on, a couple of days later, you called for a different reason, and at that point you asked Philip whether or not it was okay if Mr. Searcy and Mr. Hughes saw each other at a seminar that they were both attending.
Yes.
I don't have anything else.
Redirect.
Ms. Hughes, the prosecutor or the prosecutor's office knew that you were watching the trial, right?
I don't know what they knew.
Well, I mean, you were reporting to them throughout the trial. You've been reporting what you've seen and anything that can help, right?
Objection is characterization that she's reported. I think that there's 2 instances that have been talked about, but no reporting.
Restate your question.
Well, Judge, you've had contact with the prosecutor's office throughout the trial, right? That's what we were just talking about.
Yeah, here and there. Yeah.
Okay. So when you're contacting the prosecution, you're talking about what you've seen. Some of the times you're talking about what you've seen, right?
You make it sound like I was like watching and then calling real fast. Like it wasn't like that. Like sometimes people would text me, hey, what about this? You know, is this important? And if people would send me an email, or I would see like when the t-shirt thing came up, then I called and told them something that I remembered that might have to do with that.
Okay, so with the t-shirt thing, obviously it would be obvious then that you were watching the trial if you're talking to them about the t-shirt.
Well, I actually didn't see that part in the trial. I received a text from Taylor Searle, and he said if Travis had a t-shirt made, he would have gone through me. We had a t-shirt business together. I never made that t-shirt. And I said, what t-shirt? And he told me.
Okay, so the specific t-shirt example wasn't because you were watching trial?
No.
Okay, you said that you would receive text messages and emails?
Yeah.
From whom?
Well, not me specifically. Somebody had sent a message to Chris on Facebook, and I don't know. They're not like a friend of his. It's some random person.
Okay, so you would receive those and do what with it?
I just called and said, hey, this person said this, and he said, okay, thank you.
Okay, you would call who? Philip?
I called Philip, I think.
Okay. So any helpful information you would call the prosecutor's office? Is that a yes?
Yes.
All right. And when you got the call from Philip about Gus Searcy, he never advised you not to have any contact with Mr. Searcy, right?
No.
Okay. Thank you. Thanks, Judge.
Thank you, Ms. Stepdown. Any other witnesses?
Judge, we do have Mr. Searcy is present. As I explained yesterday, we had no intent on calling him as a witness, but the state has advised us this morning that they were not interested in Mr. Searcy's further testimony. I know the court, seemingly the court may have had questions for him as well related to the phone number. I don't know if those questions persist or not. He is here today. I'll bring him in. The court also ordered that he be restricted from doing interviews at this point in time And he is asking that that restriction be released. So we'd like to make record of that this morning, that no party has any more interest in him, and release from his subpoena and restrictions.
Any objection?
No objection. I would note that the conversation that we had on the record yesterday was involving Mr. Searcy was whether or not he was to appear telephonically. And we all agreed that if there was a need for him to appear, it would be fine with everybody that it was telephonic. And the state would then indicate at some point, if we needed him, that we could just get him on the phone. So while he's here, I suspect he just wants the limelight, but I have no questions for him.
All right, I will release Mr. Searcy from his subpoena and the previous order that he not participate in any media interviews. Mr. Searcy, I'm releasing you from your subpoena. You are free to go, and you may participate in media interviews at your discretion. All right, thank you for being here. Other witnesses?
Judge, well, yes, we're going to try to get a hold of Ms. Juban. The other issue being Ms. Hughes is here. We have a subpoena for which to serve her on as a potential witness for the trial, and we would ask that, well, we're going to do that now, but also that she be excused from any further proceedings and be restricted from watching the trial, as was the order previously.
All right, Ms. Hughes, you are going to be receiving a subpoena here momentarily. What that means is that you should not discuss anything about your testimony with anyone other than the attorneys, and you should not watch the proceedings from this point forward. All right? Mr. Nurmi?
Judge, it appears we're not going to be able to call Ms. Gibbon today. So no further witnesses today.
I'm wondering what the reason would be. Do we have a working number, or or what the problem is?
Well, Mr. Nermi, are you at liberty to discuss why we can't have the witness testify today?
We're not able to get a hold of her.
All right.
Judge, my understanding is that the number that we have is not working. So there's a problem with that.
Well, in any event, she's not available. Do you have anything else that you want to present in terms of evidence related to your pending motion?
No, Your Honor, not in terms of evidence at this time. Something tells me we will in the future as this trial goes on, but not at this time.
Mr. Martinez, anything you want to present at this point?
There has nothing that been shown. The issue involves Chris and Sky Hughes. There has nothing that has been shown that indicates that they did anything improper or that the state did anything improper. They may want to call anybody in the rest of the world, but that will not add anything to this inquiry. So I'm asking the court to find that there is no prosecutorial misconduct.
Well, now that the state has informed us they don't have any surprise witnesses popping out of the room, I guess we could go to the argument portion of this. There has been, and what the case law tells us, judges, if misconduct of the prosecution so infects the proceedings with unfairness that Ms. Arias cannot receive a fair trial, then a mistrial is warranted based on prosecutorial misconduct. And it is our position that we are there and then some. In that regard, as far as what misconduct has occurred during the course of this trial, there's been so much, and there's been so much that has preceded this trial, that I could go on for hours. But instead, I'll just limit it to what I might call a greatest hits list. Even as it relates to this hearing, when the initial evidence was brought forth, Mr. Martinez and the state brought forth two surprise witnesses that we did not know anything about. They claim, oh, well, we didn't know what it was about, and that's not true. We gave notice, and we know they knew because Mr. Martinez had his paralegal contact other witnesses, people he knew were listed as witnesses, to get information on Mr. Searcy. He knew. And that's how he knew to bring Chris Hughes and have Mr. Abdallah on the phone. He knew, and he claims ignorance. That's his defense, ignorance. It is not a defense in this situation. And we've talked about as well, we said that through early proceedings before this court was presiding over this case, he said messages didn't exist. Text messages did not exist. Well, we heard testimony from his own detective that they were on the phone. But he files a pleading saying text messages don't exist. We also, in this greatest hits list, have the testimony of Detective Flores. Detective Flores goes to the Cronus hearing and says that it was Dr. Horn's opinion that the shooting came first. At trial, Dr. Horn testifies differently, and then even within the context of this trial, Detective Flores was on cross-examination. He was asked asked to explain the discrepancy, shall we say. His testimony was that it was a misunderstanding, and this is laid out in the special action that we filed with the Court of Appeals. He says it was a misunderstanding, I misunderstood what Dr. Horn said, repeatedly. Then, on redirect, Mr. Martinez asked him, were you substituting, whose assessment was it about the gunshot first? It was mine. I was substituting my own judgment. That's what he said during redirect. One of those is not true. We know that. We know that either he misunderstood or he substituted his own judgment. Both cannot be true. Those statements cannot be reconciled. Also, throughout the course of this trial, the counsel for the state has yelled at witnesses, has thrown evidence on the ground, and then as the evidence shows today, he did something which is in direct violation of a court order. We filed a motion, and this court granted a motion saying that the witnesses to this trial were not to watch the proceedings involved. That was ultimately an extension of what we call the rule. Given the media coverage, the court grants that extension, and Mr. Martinez knew that Chris and Sky Hughes were on the witness list. He knew they weren't supposed to be watching the trial. Now, the court order may not have been completely enforceable against them in Utah, but he knew. And his assistant or paralegal, whatever his title is, Philip, that we've learned of today, had contact with Miss Hughes. Miss Hughes just told us this morning that, in fact, yes, whenever something was wrong or something she thought would help, what she called Travis's case, but ultimately the state's case, she said, yeah, she would let him know. She would call Philip. She would speak to Mr. Martinez. They asked, there was even comments about, did you ask whether you were on the witness list? He didn't say they were listed. He didn't tell him that. He knew they were listed. He knew it. He said he didn't know if they were going to be called or not. So the sin does not lie with Chris and Sky Hughes because the order was not enforceable upon them. The sin lies right here. Because he knew it, he's an officer of the court, and he acted and procured information in violation of that court order. That, again, is more misconduct that gets us past that issue of infecting the proceedings. Because he is then getting coached by a witness that he knows not supposed to watch the trial with tidbits of information that she thinks would be helpful. So the question becomes, what do we do? What sanction, if any, is appropriate? I would submit to the court to have impose no sanction is to condone the behavior. Is to say there are no consequences for the behavior. That does not seem appropriate in this context. Ms. Arias' life is at stake, and the state is violating an order of this court. Has made misrepresentations, and if there's no consequence, there's no reason to stop. Now, is there? Now, there's no doubt about the fact that a mistrial is a severe remedy, but we ask for it given the misconduct and the level of misconduct in this case. But I would also submit to the court that there are other remedies available. Well, one related to the mistrial is that we would assert not only should a mistrial be declared, but the Maricopa County Attorney's Office should be withdrawn from the case because they have procured information in violation of the court order. But I would, as I said, as an alternative to a mistrial, the one clear remedy this court has is to remove or negate the finding of the death penalty. That the death penalty is eligible. This is a sanction that can be imposed on the state because it doesn't affect the merits of the case. It is a less onerous sanction. What we're really talking about, Your Honor, is removing a sentencing option. The Arizona law, and we instruct the jury on this, is always satisfied with the life verdict. The sentencing option of death is not a requirement under Arizona law. It is something that they are seeking. But their behavior and misconduct in this case warrants that potential to be taken away. We think it warrants a mistrial, but if the court's not so inclined, we believe that removing that sentencing option is also a sanction that this court should consider.
Mr. Martinez.
There is no law that was cited by the defendant that indicates or that prohibits the prosecution from contacting individuals that may have information, whether they are subpoenaed or not. In this case, these individuals were not subpoenaed. There's no indication that the defendant was going to call them. The subpoena was sent out today. And the state indicated that we would not be calling them as a witness. So for the defendant to then shift the burden over to the state to contact a person, anybody in the world or anybody that they may call, and say, these are your obligations. That's not what the rules contemplate. If they really were going to call these people as witnesses, why don't they subpoena them? As they indicated to you previously, the process to get a witness into this court out of state is long and protracted. And they've complained that they weren't even able to comply with that. So if they really were serious about these people as witnesses, why didn't they start the process back then? It's a sham to stand up here and say, well, these people were going to be witnesses. The other thing is that even if they were witnesses, the state can contact them. There's no prohibition, just like he can get on the phone and contact Detective Flores. They've exchanged emails before. There's no prohibition about that. In fact, that involved the TLSI issue, where they exchanged emails and the prosecutor was not kept in the loop. So this idea that somehow the rules say that the prosecution can't contact a witness, there's just no support for that. And so in light of what has been presented, the evidence, in light of all of the pleadings, and in light of the law, I ask you to dismiss what really is nothing more than a sham allegation of prosecutorial misconduct. Thank you.
Mr. Nermi, anything else?
Yes, Your Honor. In response, briefly, this is far from a sham. The misconduct upon the state and then pleading a level of victimization is almost laughable if it weren't what was happening here in the context that it's happening here. The lack of subpoena, the fact that somebody is on the witness list, may or may not be called, is something that happens all the time. Something that happens all the time. The state had numerous witnesses on their list that they decided not to call throughout this process. And it is not about contacting witnesses. That's not what we're talking about here. This is talking about information obtained that he knew was in violation of court order. He says, oh, they cite no law. This judge, and we put law in our motion asking the rule to be extended to witnesses watching it on TV. This court granted that motion. The state was present. The state objected to it, and this court granted it. It's a matter of violating a court order and obtaining information. And Your Honor, that is misconduct in and of itself, but it is but one in a series of events or actions upon the state for which sanctions should be imposed. And as the case law tells us, it is the cumulative nature of those instances of misconduct that get us to the point where a mistrial or other sanctions should be imposed, and I've listed those for the court.
Mr. Nermi, was Guy Hughes listed on the state's disclosure notice?
Chris and Sky Hughes were on, I believe, both notices. I know that they were on ours, and I don't have the exact date and time, but we could certainly provide that to the court.
Did you make any effort to contact Sky or Chris Hughes to tell them they could not watch the proceedings?
No, as a matter of fact, Judge, this court instructed the state to do that as well with their witnesses, and I believe they were on their witness list as well.
Judge, but we did file a questionnaire which indicated the witnesses that would actually be called by either side. I did not list Chris and Sky Hughes. The defense did. That's on record.
But again, Judge, and I would say respectfully, the court's question goes to Chris and Sky Hughes, not Mr. Martinez. If they were in violation of the court order, it wouldn't be misconduct. But if they contact the prosecutor's office and share information that they believe would be helpful based on the fact that they're watching the trial, that's where the problem lies. And please don't be confused by that, because we're not talking about sanctions against Chris and Sky Hughes for violating the court order. I would agree with the court. Okay, even whether we made contact or not, and we didn't know whether we were going to call them or not, but regardless of whether we made contact and said, hey, don't watch the trial, they would be under no obligation, and their disposition would be probably to hang up on us or ignore our requests. It would have been futile. The issue is the contact with the state and the state using that information.
Well, Mr. Nurmi, I didn't hear Sky Hughes testify that she told Philip or Mr. Martinez that she was providing information based upon her review of, or her viewing the media coverage of this trial. In fact, what I heard her say is that she and Chris Hughes received emails, texts, telephone calls, and that as a result of that, contact was made with the prosecutor's office. Now, it may be that she did tell Philip or Mr. Martinez that, but I did not hear her say that in her testimony.
There was a portion of her testimony where she said she had other contact, but there was also portions of testimony where she said she watched the trial and reported to them. And whether or not the state knew, whether the state knew or didn't know she was watching the trial, they knew she shouldn't have been, and they knew where this information was coming from. She was looking for inconsistencies in contacting Mr. Martinez's assistant. And I think then, and just the same when we talk about the withdrawal of the county attorney's office, it leads me to question, as we have this argument, whether the assistant to Mr. Martinez is now a witness meriting the withdrawal of the county attorney's office. This man was having contact with Ms. Hughes. And if he knew, again, and even though I would submit he did, because that's what Ms. Hughes talked about, looking for inconsistency and having contact with Philip, using a straw man does not absolve Mr. Martinez of the responsibility of violating this court order.
All right. Some of the grounds stated by the defense have already been addressed by this court, either through a previous ruling by Judge Duncan or by a ruling by this court, and some of those issues have even been addressed in a special action, which was denied. With regard to the issues raised with regard to Chris and Sky Hughes, the court finds that the defense has not established there was any prosecutorial misconduct, so the request for mistrial or some other sanction is denied at this time. All right, let's get ready for trial. Let's get the jury ready.
Just will need the exhibits.
Yeah, and we'll bring those right up. You may.